Welcome to Feminist Question Time, brought to you by Women's Declaration International, which is the leading global organisation defending women's sex-based rights against the threats posed by gender identity ideology. Many of us have been active feminists since the 1970s or the 60s or 80s, 90s, etc. We were not surprised when this new attack on women came along, and we have not changed our analysis. Janice Raymond, writing The Transsexual Empire in 1979, is the first great articulation. Also, Mary Daly in Gynecology writes a lot about this. So very clear analysis within radical feminism about these sort of threats. During this threat, we in 2018 wrote a declaration on women's sex-based rights, which lays out our position, and it's been signed by 39,344 people from 160 countries and by 543 organisations. WDI is delighted that the UK Supreme Court ruled about 10 days ago that sex is biological and that men with a gender identity are not women. This goes a long way towards implementing the Declaration on Women's Sex-Based Rights and was a fantastic surprise to many of us because we didn't think it could be this good, this ruling would be this good. So can WDI shut up shop and go back to rewilding our gardens? We're not going to do that for a range of reasons. WDI is international, and we're against the global spread of gender identity ideology. So just because UK has had this good ruling, that doesn't solve the problem globally. And of course, it's not sure it's being properly implemented within UK. So we're going to continue to promote international sisterhood, possibly with a new sort of spirit of the TERF International or the TERF Intern. But the theme of our conference in July, we've got a WDI conference in London, 26th and 27th of July, and actually a UK WDI part on the 25th. So 2.5 days of conference will be the two, Saturday and Sunday, will be about the international work that we're doing and our community of sisterhood and feminist work. Secondly, the judges in the UK Supreme Court did not define gender. So they did define sex, but they left gender as this fuzzy term. And they did affirm that people with gender identities have special protections under the law, even though they didn't say what gender is. As gender abolitionists, we don't see gender as an identity, but we see it as a system of oppression. So we're going to continue to articulate that the idea of gender identity is problematic and unhelpful and a trap for people who might fall into thinking that they are and they identify with their own oppression. We'll continue to talk about that, I think, as a sort of community, and to refine our understanding of that and what we're trying to say about that. So today we are going to hear from Marg Curnow from LAVA, Lesbian Action for Visibility, in New Zealand, Aotearoa. And that's going to start off, we'll start off with me chatting to her, finding out what's going on with LAVA. Then we're going to hear from Luba Fein from Israel, and Luba's talk is the erasure of sex-based rights in conservative societies, which is fantastic. And thank you so much, Luba, she's going to be speaking second. And then we're going to have Sally Wainwright, who is the WDI rep for Scotland, and she's going to talk about the 4 Women Scotland ruling, so the Supreme Court ruling. So we're going to first talk to Marg. Marg is from New Zealand, and she worked at Christchurch Polytechnic in women's courses, helping to set up and run courses for women returning to the workforce, an intro to the trades for women and others. These courses politicised women who came through, so has a long history in feminism and in working in those areas. And we'll talk to Marg more about it. She moved to Wellington, and I'm jumping a bit of the bio, but moved to Wellington in 2012 and had been on the Lesbian Radio Collective and then the so-called inclusive agenda, ended Wellington Lesbian Radio, and it was instrumental in Marg's decision when she retired in 2019 to put energy into working for women and girls, especially for lesbians, by joining the fight against gender ideology. In 2020, Marg set up a meeting of Wellington lesbians, and so, after a hiatus of many years, Lava was reformed to fight a new form of lesbian invisibility. So, Marg, thank you so much. It's the middle of the night for you
It is.
in New Zealand. So, thank you for coming on. And can you tell us about Lava and what's going on with it? What's important about it?
Sure. Thank you for the opportunity, Joe. It's great to be able to be here, even if it is the middle of the night. Yeah, Lava was first formed in 1988, and this is, I think, quite important because Lava was formed initially to work for lesbian protection under our Human Rights Act. So homosexual law reform came through in the mid-80s, but there was still no protection from discrimination. And the key thing that Lava wanted was that not only are lesbians in the Human Rights Act and protected against discrimination, but that actually the word lesbian is used. And so we became the first country in the world to have the word lesbian in our legislation with same-sex orientation. So we have quite a proud history with that achievement. And we were, of course, the first country in the world to give women the vote. So we're somewhat gutted about where we've got to after that proud beginning. And now it's a new form. It's the same issue. It's our visibility, but we're also back to fighting for our right to be accepted as same-sex attracted women. Our Human Rights Commission has relabeled us as same-gender attracted. And when we did an official information request, they couldn't actually say how that happened. They didn't know who'd authorised it. They didn't know when it had happened. It's just crept in to the Human Rights Commission and through them to other government organisations. So in many ways, the same as it's happened everywhere else. But we decided we wanted to keep using the Lava name because it is about our visibility as women and as lesbians.
Is there a definition in New Zealand law of what gender is?
No, in fact, it's very contradictory because we have two pieces of legislation around gender and they define it or talk about it quite differently. One says it's fixed and one says it's fluid, but they still don't define what it is.
Are they saying it's fixed to sex? It is a synonym with sex, or they're just saying it's a thing that is fixed?
It's a thing that is fixed, but that everybody has, of course.
And you've got a court case at the moment. So what's that case? What's happening with that?
What we have happening is back in 2021, Lava was excluded from Pride. We had booked and been given a stall at the Pride Fair. And then out of the blue, about 3 or 4 days before the fair was due to happen, they emailed us and told us that they couldn't give us a stall, initially not saying why, but obviously we followed up and they said it was because of our views and because we are trans exclusionary and because as the organisers of the festival, they had an obligation to protect trans people and they would be harmed and be unsafe if we were there. Even though we weren't actually going to talk about our views or what they were. They didn't ask us what the purpose of our stall was. They just excluded us. And it's a familiar story, I think. Lesbians all over the world are being excluded from Pride.
And that's the sort of form of invisibility. So is that what you're saying?
That's
that
right.
by
Exactly.
saying Lava cannot be at Pride, you have to go back into the closet in a way?
It's no longer acceptable to be same-sex attracted. So that's what we're fighting for, is the recognition that we're not same gender and for the right to hold our views and have those views respected. Because we don't have in our Human Rights Act the protection of philosophical views in the same way as you do.
Yeah.
We have the protection of political opinions. So we're using that we have a right to these opinions.
Well, that's very
So,
interesting because if you
mm,
win that, then that's
mm,
a precedent that it doesn't just have to be a philosophical view. It can be a
exactly.
political opinion, and the
Yeah.
personal is political. Feminism is
Of
political,
course,
isn't it?
exactly.
How far has the case gone and what's going on with it?
Well, we now have our hearing dates. There's been all the things that I had no idea need to happen when you do this sort of thing. We had or do have an expert witness who's a professor of political philosophy, and so who talks about our view as being worthy of protection and being political, because up till now it's been defined very narrowly under the Act as party political. You have a right to be a member of the Labour Party and not have that affect your job, etc. But we are broadening that and saying, as you have said, that the personal is political and that these views are political and worthy of protection. And Pride in response is saying that we are bigoted and hateful and harmful and transphobic and don't respect any of them and want them all to disappear and die and so on.
When's the date? When's it coming up?
Well, there's 4 weeks, so it's split. It's not 4 weeks in a row. So our first week is the end of July, the last week in July. Our second week is the first week in September, then the third week in September, and then the first week in October. So it's very spread out. And this is because they have so many expert witnesses, 19 expert witnesses, and they have to be cross-examined and responded to. And our lawyer is trying to change that, because none of them are addressing the political opinion issue. What they're doing is just saying that our views are so disgusting and terrible that they don't deserve protection. And they've got 19 expert witnesses to say that that is true. For a long time in New Zealand, it's been very difficult to get our views across. They're not, the mainstream media doesn't represent them, or hasn't until quite recently. We do feel the tide is turning, but until recently, it's been very, very difficult to get anything published, to get interviews, just to get the issue out in the open and talked about. And
And
so
yet,
most people don't understand it. Interesting things happen, like our current government, for all that they're a right-wing government, whom I find it very difficult to support. The coalition, one of the coalition partners, has been quite strong and clear on this issue. And the Associate Minister of Health has issued a ruling that the Ministry of Health, the communications they put out, must use biological sex and not refer to people with uteruses and so on. And that was a
great.
very important statement that came out just 2 or 3 days before the UK Supreme Court ruling. So that was brilliant timing. It's hard to know what's happening for ordinary people, because the view that let them be, no one's being hurt, be kind, don't be horrible, has been so strong. But there has been some research over the years that has shown quite clearly that most people do not agree with the extremes of gender ideology or gender identity ideology.
Hmm.
But that the last research was, I think, about 18 months ago, and it certainly showed a majority of New Zealanders did not want men competing in women's sports and so on,
Yeah.
and believe that we need our spaces and we have the right to protect our spaces.
In the Supreme Court ruling in UK, they
Mm,
mentioned lesbians a lot, and
mm,
it was incredibly gratifying that
yeah,
our legal establishment, the pinnacle of the establishment in Britain, cares about women-only spaces and the ability of lesbians to have the right to be same-sex attracted. And that seemed to be a really big step for, I think,
yeah.
for the mainstream society in Britain, and the establishment believe in both of those things.
I think that one of the keys around that for me was that they talked about the coherence, or the lack of coherence, in that view that says, anyone can be a woman, and then all that means, because it is an incoherent position. It just doesn't make sense. And that's what we're pushing. And, in many ways, it reminds me of the 70s, when we were first discovering feminism and speaking out about it and into the 80s. And what used to happen was the men would say, but what about us? Why do you hate us? And trying to get that message across, this is not about you, this is about us. And it's still the same. This is not about trans people. This is our position and we're entitled to hold it. And that's what our case is about, that we are entitled to hold this position. It's not hateful, it's not bigoted.
That's fantastic as well. It's not about you, it's about us. Exactly.
Mm.
What about Lava and other lesbian organisations in New Zealand? How are they doing? Are you sort of managing to sort of have events and keep going despite all this?
We are, but there are very few lesbian organisations now because most of them have either folded or have men as part of them. In Wellington, there's the Lesbian Library, which is still going, and there's Lava. We're just about it. There's lesbian newsletters that are online, but there's very little now. And some of that is just about the times, isn't it? We felt like the battle had been won. That was how it felt here. We can relax and get on with our lives. And then suddenly we're back into fighting again and saying, hey, here we are. And we're not going to sit around and not be recognised and not be respected. And you can't tell us that our views are harmful because they're not harming anybody. I mean, lesbian's always been a word that a lot of women have avoided using, and now it's certainly not okay for younger women to be lesbian. And we know that young same-sex attracted women are being funneled down the trans path. I think becoming non-binary is what a lot of them are doing. And then they move from there into transition. And it's very sad. And women our age, 60s and 70s, are wanting to be kind. So many of them are still wanting to be kind and don't seem to understand that gender identity ideology is actually a threat to women. So that's Hilary and I outside the Michael Fowler Centre, which is where the fair was being held. And Hilary and I are the plaintiffs in the case, because Lava couldn't take the case because we're not an incorporated society. We don't have formal legal standing. So Hilary and I are doing it on behalf of Lava. So it's not us. I mean, from the point of view of the courts or the tribunal, it's us, but everyone knows that we're doing it for Lava. Can I just say that one of the things we have to do is fundraising. 4 weeks in court is really expensive. If women want to look at our website, it's very simple, lava.nz. You can read more about the case and you can donate money if you're in a position to do that. New Zealand only has 5 million people, so we struggle to raise the sort of money that's needed.
So we're now going to go to our second speaker, who is Luba Fein. And Luba Fein is in Israel, from Israel, and she has been working on prostitution for many, many years and been doing fantastic work for women's rights long before this sex-based rights stuff turned up. And I'm sure we'll be carrying on afterwards. She's spoken on WDI before and also at Filia and in many conferences worldwide and is known to be a real expert. And Luba's going to talk to us today about, the title of her talk is The Erasure of Sex-Based Rights in Conservative Societies, which is a fantastic title. So thank you so much for coming, Luba, and over to you.
Today, I would like to talk about the erosion of sex-based rights for women in my country, but I won't speak only about that because after all, the patterns of erosion are pretty much the same everywhere. We have everywhere the loss of single-sex spaces like showers, restrooms, hospital wards. We have male inmates placed in women's jails and prisons. We have legal sense changes on ID documents becoming easier and easier. We have statistics losing their meaning. We have freedom of speech issue. The same, more or less the same everywhere. So you all know this. And this is why I'm here to talk not only about the well-known lie that a man can be a woman, but also about a less discussed lie the idea that the erasure of sex-based rights is something that only happens in progressive or liberal countries. And we all know it. We call transgender politics progressive, left-wing, but this is just framing. And many conservative countries are cases that prove the opposite. I do not live in a liberal country. Israel is very eclectic. Politics, institutions, very eclectic. On one hand, women here enjoy several important rights. We have no ban on abortion or no discussion about ban on abortion. We have protections against discrimination at work. We have laws requiring women's representation in several institutions. And we even passed a law banning the purchase of sex, which is great. But on the other hand, in the past 25 years, Israel had 9 different governments, and of those, not a single one was left-wing. Only 2 were centrist or mixed, and 7 were strongly right-wing. Every single government included the religious or even ultra-Orthodox parties. And beyond that, we have no separation between religion and state in Israel. We have no civil marriage or civil divorce. The pay gap between the sexes is large. Women's representation among lawmakers is insufficient. So bottom line, we are very far from what people usually call a progressive country. We are not Scandinavia. We are actually a pretty conservative country. And yet, the gradual erasure of sex-based rights has been happening here for quite a while under right-wing conservative governments on their watch. And here are a few examples. The procedure for changing legal sex registration. In February 2020, Israel, and it was the beginning of COVID policies, Israel's Ministry of Health issued a directive making it possible to change the legal sex in the population registry through a relatively quick and easy process. It is not full self-ID like Germany, but the change is based almost entirely on self-identification. It does not require undergoing any medical procedure and no hormone treatment. It only requires approval from a 3-member panel, a mental health professional, a medical doctor, and a public representative from the transgender community. This is the committee. The public was given a theoretical opportunity to file objections to the directive, but this invitation was never publicly announced anywhere. I found it on someone's Facebook, and of course I submitted an objection, and some of my feminist friends also submitted objections, but none of us received any response. We have no idea whether our objections, whether they were read or considered, just nothing. And the legal sex changing process is just what I told. It was accepted. We didn't get to speak or communicate with anyone. Unlike many just I want to give another example. The sex purchase ban is very controversial and divisive issues in every country, but it is not the same like changing legal sex, because sex registry affects everyone. Sex purchase ban affects, for me, this is my work life, but for most people, it is not that relevant. Still, it was discussed in committees, it was in the media, the public debate was very wide. Here, we only had this new directive, and that's it. And that's it. Nobody got representation or chance to talk. So unlike many other countries where similar changes were accompanied by fierce public debate, where women and women's organizations had the chance to present arguments, speak in parliament, run campaigns, in Israel, the change was made during COVID behind closed doors, and most of the public isn't even aware of it. like many Israelis are spoken to, still believe that you can only change the sex marker on your ID after undergoing major invasive surgery called the sex reassignment surgery. So this is most people think this is the necessary procedure, while in reality you just declare that you're a woman or a man, your preferred gender in front of some committee. And it is also important to emphasize that during this entire period of directive and change of policies, the Minister of Health was an ultra-Orthodox politician, not just right or left, ultra-Orthodox politician, not some liberal or progressive figure. And it happened on his watch. Data collection. As of today, all official databases in Israel, including the police or Central Bureau of Statistics, they record a person's legal sex as stated on their ID and not biological sex. Such data collection risks becoming meaningless and practically useless because legal sex registration isn't the same as real sex, right? Women's jail, another issue. We have in Israel is a very small country, and we have only one women's jail, Neve Tirza, with 200 inmates. Usually it is full. And it is important to say that women make up less than 5% of the total inmate population. Like we have 5% women and 25% men. Women population in inmate population is very vulnerable with a specific criminological profile, and they are more often victims than hardened criminals. And here I'm citing prison's chief official. It is recognized that many female inmates, they are victims, they are abused women, they are women prostitution, abandoned children in their past. So today we have numerous male-born transgender inmates in Neve Tirza, the women jail. In 2022, a story was published in the media about a transgender inmate who had been imprisoned, a male, yes, he had been imprisoned in 2019 for a violent offense. And he was initially held in isolation in men's jail, but later transferred to the Tirza based on a court ruling. The court sent him to there. And after his release from the jail, he sued the prison service and was awarded about, I'm translating it to euros, 30,000 euros. Compensation for what? For spending 3 days in isolation and for not being provided with vegan food, yes. So naturally, this story creates a strong incentive for the prison system to house future male-born transgender inmates directly in the women jail, which is very full and with very vulnerable population. Education system. The education system's policy regarding students who identify as transgender is vague. And it seems like schools differ in setting their own policies, but over the past 5 years, I'm reading press, I'm reading media, there have been cases where schools allowed male students identifying as transgender to use girls' bathrooms and sleep in girls' rooms during overnight school trips. One of the incidents ended with the trans-identified boy was beaten by angry girls, and he needed hospitalization and dropped out of school. So this is clear sign that the solution failed badly, and the girl didn't want them there. Right now, I have three daughters. Two are still in school, and I don't know how I would cope with this situation because we don't have a very clear directive, and in the area where I live, it could be situation with the minority of parents fighting who are framed as conservative, fighting majority of parents who support vulnerable transgender students and not the girls. Now, psychiatric hospitals. In 2021, a directive was issued regarding psychiatric hospitals to accommodate transgender patients according to their self-identified gender. Yes, you heard it right. Psychiatric hospitals. Where possible, they say the patients should be placed alone in a room. Okay, thank you for that. Either in a mixed or gendered unit, depending on their wishes. Nothing is, in that directive, nothing is said about women's wishes, of course, but they should get a private sleeping and space and bathroom area whenever feasible. All the directive says all while trying to respect the needs of other patients as well. Like, I don't really believe that this system to respect wishes of psychiatric patients, female or male, and especially female. And I personally know women who even before 2021, they were hospitalized in psychiatric wards and forced to share rooms with male transgender patients. Rooms. Nobody asked them about their comfort or wishes or preferences or identification. And we are talking about an extremely vulnerable population. Women whose psychiatric conditions often include difficulty setting boundaries, difficulty with sharing any spaces with male population. Welfare institutions. In 2022, Israel's Ministry of Welfare issued guidelines stating that male-born individuals who identify as transgender must be placed in facilities according to their self-declared gender, not their biological sex. And this includes, listen to me, locked shelters for at-risk teenage girls, where male-born youth identifying as female are now housed. Supposedly it should create a safe and supportive environment. This is what was published, but for whom? Similarly, adult men identifying as transgender are now allowed into women's rehabilitation settings, such as shelters for survivors of prostitution, homelessness, addiction, at-risk youth. Like, ideally, there should be a separate room or dedicated facilities for transgenders, but it is not always implemented, and we should understand that those facilities are usually underfunded. So separate rooms for people, first, it is not always feasible. Second, this is a huge privilege. Many vulnerable women need separate rooms. Why won't they get them? So regarding facilities for people with disabilities, the guidelines allow male-born individuals to be placed in women's rooms with the consent of the woman and her legal guardian. And again, we are speaking about women who are often abandoned. Nobody cares about them. They have a problem to set boundaries. And we are speaking about their consent, so-called consent. It is very easy to pressure those vulnerable women to share spaces with whoever. And now the problem is public discourse. In many countries, in UK, in New Zealand, in Australia, in the US, we face intensive public discourse about sex-based rights. And which is very important. The discourse is very loud and often very feminist. And in Israel, as a conservative country, the biggest problem is that all the above mentioned policies were set almost secretly, and there was no public debate. And the public only learns about all these changes through scattered media reports. Sometimes we found some article, and sometimes people don't even know what is going on. As I say, the people are not aware of the policies. And then right-wing politicians and journalists, they don't intervene. And if they intervene, they don't use the typical rhetoric of transgender human rights. This is indeed the sort of progressive language. And you won't see them standing around with signs that trans women are women. They won't do it. But on their watch, the erasure of sex-based rights is quietly happening. They are the ones signing on directives and regulations, like the one I told you about regarding legal sex changes. And sometimes you will hear a conservative populist journalist, an influencer, or some politician. He goes on a rant against transgenders or whatever they call LGBT. And usually those statements are crude, not intelligent, not analytics, and they have nothing to do with the feminist critique of sex-based rights being dismantled. But even that is enough for any serious feminist criticism to immediately get labeled as a right-wing position. So it is in this legal environment, it is a social environment, it is very easy to silence us. Many political views and behaviors everywhere today in every country. So those views shaped by tribal loyalty, not deep or fair thinking about divisive issues. People are not learning topics before they choose attitudes. And in Israel right now, society is very polarized. There is a deep us versus them mentality, conservatives versus liberals, conservative institutions like the government versus liberal institutions like the media and the courts. So when everything is so polarized, most people simply adopt the full package of ideas that belong to their side. And as a result, very few people and few women are willing to take an intelligent, non-tribalist look at sex-based rights. In the media, in major daily newspapers, you will find articles like those. An opinion piece claiming that the next transgender child who commits suicide is the responsibility of a well-known gender-critical activist, and she is named personally in the article. They say that the next trans child blood will be on her hands. I have seen a blog post claiming that TERFs in Israel are importing extreme right-wing discourse from the US. This post was entirely based on quoting random trans activists from social media. I'm an admin of the biggest feminist group in Hebrew. So my group was also mentioned as alt-right. I'm not alt, not right, but that's how it was mentioned. And yes, and I was also blamed, my group was blamed for importing right-wing American rhetorics. Giant newspapers feature articles about trans kids, and the framing is always the same: a heroic child and heroic parents fighting against evil transphobes who want to kill them. So civil society organizations are also fully on board. Many women told me that they were interviewed for jobs at human rights NGOs or welfare NGOs, and they told me that they were asked in job interviews for their views on transgender issues, even when the organization had nothing to do with that topic. Under such conditions, there is no real chance of advancing sex-based rights, right? Because everyone is interviewed in advance. So when I look at the fantastic legal victory of For Women Scotland, I realize that this kind of success isn't possible here. There will never be a strong enough group of women organizing around this issue. There won't be enough fundraising, at least not from within feminist circles. If we insist staying within feminist circles, we will never get money from no one. And most likely, the courts would treat a feminist position as a threat to rights, rather than an effort to defend rights. And of course, we are seeing similar patterns, not only in Israel, but also in other conservative countries, like India and Brazil were discussed previously in this forum. This is just another reminder of how important it is to stop framing our struggle not as a left-right wing issue. And we should start framing it for what it really is: women's right versus women's oppression. Thank you.
Okay, we're going to move on now to Sally. So Sally Wainwright is WDI rep for Scotland. She is the co-editor of Women's Rights, Gender Wrongs. She is an expert on this issue. She spoke to us before about the significance of the issue, and I mean, it's just, thank you so much, Sally, for everything you've done and for winning. So without further jubilation, I'm just going to hand over to you and hear what you have to say about it. So over to you, Sally.
As I'm sure everybody knows already, the case was intended to decide what the definition of sex was in the Equality Act. The specific question was whether men with a gender recognition certificate, that's those who've legally changed their certificated sex, should be considered women for the purposes of the Equality Act 2010. There's only about 9,000 people in the country who have gender recognition certificates, but the ruling itself has a much wider practical application because it clarifies a lot of issues relating to people who self-ID as well. And it had already been established that people who self-ID, or men in this case, who self-ID are not considered women for the Equality Act. So technically they weren't part of this discussion. And the Act gives protection against discrimination and harassment for various protected characteristics. And the protected characteristics, there's 9 altogether, but the ones that are relevant for us today are sex, sexual orientation, gender reassignment, and pregnancy and maternity. And gender reassignment, if you're not familiar with it, is a very British thing, but it sort of means self-ID. So you self-ID, but you don't legally get any change, but you socially self-ID. The Act does allow for some discrimination. So, for example, we can discriminate against men in women-only spaces, and that's how we get women-only space. So the question was, as I say, does GRC change a person's sex in the Equality Act? And the role of the judges was not to decide what's right and wrong. The role of the judges was to what's called statutory interpretation. It was a case where they were being asked to decide what the law actually already says. And if it's unclear, they can examine the context of the legislation and look at the meanings of the legislation, the things within the legislation, to see what they think was intended. A bit of a spoiler alert, but I think you already will know the answer, which is that the terms woman, man, and sex were found to be biological, which is obviously very, very important for women. And the terminology that was used was biological sex, referring to sex at birth, and certificated sex, referring to sex attained through the acquisition of a gender recognition certificate. And the judges used that language throughout the ruling. It's a long and closely argued document. It runs to 88 pages, and obviously it's very limited what I can do in just a short time here. What I'm going to try and do is focus on the reasoning that the judges used in making their decision, because I think that might be most helpful, particularly to people who might be trying to have similar arguments in other countries. But there's an awful lot that obviously inevitably is going to get left out. So what the judges did was they went through the Equality Act line by line virtually, and they discussed them in the ruling. And I recommend reading the ruling. It's very easy to read, and it's very, very interesting. So one of the things that's interesting is that some key themes run throughout the judgment. And I think that these are really important sort of general principles for people to consider. So the first is that words should normally be given their ordinary meaning. So in other words, unless there's a reason to think that woman doesn't mean what we all understand the word woman to mean, then it means what we understand it to mean. And also they must have a constant and predictable meaning throughout a piece of legislation. So you can't use woman to mean one thing on one page of the of the Act and to mean something different on a different page of the Act. And that was important because the Scottish government was arguing that sex should be interpreted as being certificated, except in rare cases where it obviously, because of the context, needed to be treated as biological, for example, in the context of forensic medical examinations, because there was a piece of legislation where sex or gender had been central to the argument, or, for example, in the case of pregnancy and maternity, it should be taken to be biological. And the judges said you really can't have both. It's got to mean one word has to mean one thing all the way throughout. And there's an entire section on the importance of clarity and consistency. It must be possible for service providers to identify who is a member of which group. So if you have a group of people that are called men and a group of people that are called women, you have to immediately be able to know when you meet somebody or when you're talking to somebody, which of those two groups they fall into. Actually, I think it's quite funny, really, because when the GRA, the Gender Recognition Act, was drafted, the people who drafted it wanted the possession of a gender recognition certificate to be kept secret. I think they thought that we wouldn't know that a man was a man if we didn't see his gender recognition certificate and would mistake him for a woman. But the result of that, and the judges have made very good use of this provision, in my opinion, the result of that is that service providers aren't allowed to ask to see a gender recognition certificate. Well, technically, I think they're allowed to ask, but they're not allowed to do anything with the information. So it kind of comes to the same thing. So in practice, that meant that because you can't ask to see a gender recognition certificate, you have to assume that any man that rocks up and says that he's a woman is, because you mustn't discriminate in case he's got a GRC. So in practice, that provision has been used in a way to say, well, the problem with GRCs being secret is that it extends any rights that a GRC holder might have to everybody who self-IDs. Again, with these general themes, some of the points that the judges made in many different ways were that using the notion of certificated sex would cut across the definitions of woman and man and the PC of sex, the protected characteristic of sex, in an incoherent way. And this word incoherence really useful and important, because I was talking to some lawyers immediately after the judgment, and they said, oh, coherence has been introduced as a new sort of legal test for legislation, because it comes up time and time again. If you interpret things, if you interpret sex in the Act according to them to mean certificated sex rather than biological sex, that makes a lot of the provisions of the Act incoherent, and they were very concerned about coherence. So that's very useful. And the other thing that they were concerned about was that using certificated sex would lead to heterogeneous, in other words, mixed sex groups, rather than distinct groups with a shared biology, which they said led to shared disadvantage and discrimination. In other words, what that means is that if you use certificated sex, the category of women means biological women who don't have a gender record, but excludes biological women with a GRC. So it includes some biological women, it excludes some biological women, and it includes biological men with a GRC. So you've got this group that's just a mishmash of people, and there's no way of knowing whether somebody's going to be in the group of people described as women or not. And the judges didn't think that that was very helpful, I think one could say. So one of the issues that they looked at was the question of pregnancy and maternity, because there's a lot of provision in the Equality Act and indeed elsewhere that relates to pregnancy and maternity. Some of them are very complex, and they're long and complex, and I'm not going to go into them just now. Mostly they refer to employment rights, but all of them talk about women. They use the word women, and they use, I hate to say this, she, her pronouns. I mean, they use female pronouns throughout. So, you know, a woman, or the employer has to speak to her or whatever, so that it's always about women, and only biological women can be pregnant as a matter of biological fact. I mean, there's no prospect of a biological male becoming pregnant. So that was also seen as important. And what they said was that if you use certificated sex, then women with a GRC would become legally men. So a woman who was pregnant but was had a GRC would be a man who was pregnant, and he would then not have any pregnancy or maternity rights, because they're all written only for women. And the Scottish government acknowledged that, and had to stand up in open court and say that that was the situation. And the judges said that it's difficult to see any good reason for such an approach, which is very much echoed what they'd said about the notion of heterogeneous groups. They'd said that they saw no good reason why Parliament should have intended sex-based rights and protections to apply to complex heterogeneous groupings and so on. So a lot of this time they're looking at, what could this possibly have been what Parliament meant? No, it can't, because there's no good reason why they would have done this. Allowing men to be pregnant, certificated men to be pregnant, would break the principle of words having a consistent and predictable meaning, because pregnancy and maternity provisions would become incoherent, that word incoherent again, and unworkable unless woman and man have a biological meaning. So the Scottish government had argued that you should interpret the meaning of the word according to the context in which it appears, as I was saying before. So they were saying, oh no, woman, it means a woman with a GRC is a man except when she's pregnant, and then she counts as a woman. And that just obviously is nonsensical, completely nonsensical. So the other thing that the Act looks at in this section really is the protection of women and the particular risks that women face in relation to work and training. And again, the judges argued that if you use certificated sex, it makes it impossible to identify what specific risks there are to women at work because of these heterogeneous groups. So if some biological women are in the group called men, then the specific risks which refer to women would actually also relate to some of the people in the group of people called men, because they would be women with a certificate would be men. So you couldn't then say there are certain specific risks that just apply to women, because the individuals to whom those risks would actually apply would be spread across both groups. And again, that then became completely nonsensical, really. They also looked at the question of gender reassignment. And this was very interesting because this case was sort of about whether people with the gender recognition certificate had rights that we'd already established didn't apply to people who self-ID. All of those people in the Equality Act come within the category of people with the protected characteristic of gender reassignment. So in other words, anybody who says that they're trans has the protected characteristic of gender reassignment, whatever stage of their transitioning they are, even if it's just that they say, I think I'm going to trans, to they've had full medical and surgical interventions. All of those people have the same protected characteristic of gender reassignment. So this case was to see whether those people within that group who had a gender recognition certificate should be counted as women for the purposes of the Act, effectively for being able to come into women-only spaces and to use women-only services. And what the judges argued was that if you use certificated sex, this would create two different subgroups of people who have the protected characteristic of gender reassignment. So on the one hand, you'd have people with a GRC, and they would have greater rights than people who do not. And because the Equality Act is all written about the rights of people with the protected characteristic of gender reassignment, the judges said the Parliament couldn't have intended some small subgroup of those people to have more rights than the rest of the people with the protected characteristic of gender reassignment. They didn't think that was they didn't think that pointed to the use of certificated sex within the interpretation of the Act. Again, they came back to this issue of how would service providers know which group somebody fell into, because, and they make this point on several occasions, that there is nothing in the legislation that says that to have the protected characteristic of gender reassignment or to get a gender recognition certificate, you have to make any physical or physiological changes to your appearance or your body or anything. So there's no reason why people in the group with GRCs would look different from the group of people without GRCs. So you wouldn't be able to look at somebody and say, oh yes, this person falls into the category of women and this person falls into the category of men. And as I already said, you can't ask if somebody's got a GRC because that information's private. And again, they said there's no good reason. See this thing, no good reason. You have to have a good reason for doing any of these things. There's no good reason to treat people differently, depending on whether or not they possess a confidential certificate. In other words, it's what they're really saying is it's absolutely absurd to think that if somebody walks into a room, the fact that they've got a certificate that you're not allowed to see and that you can't know about should give them different rights than anybody else. It just didn't make any sense at all. And so again, they argued that this mitigates against using the concept of certificated sex. And in other words, it's better to use biological sex. And then we came to the question of lesbians. The Equality Act acknowledges 3 types of sexual orientation. That's people who are attracted to the same sex, lesbians and gay men, the opposite sex, heterosexual people, and either sex, so people who are bisexual. And the judges argue that that definition means that lesbians must be females who are sexually orientated towards other females. So they saw that female was important there. And they said that this is a coherent and understandable definition of what a lesbian is using the biological understanding of sex. But if, on the other hand, you were to use the certificated version of sex, then this would weaken the protections given to people on the basis of their sexual orientation. Because a trans woman, which they use the word trans woman, but they go out of the way when they say trans woman to put in brackets biological male, which I love. They don't want anybody reading this to be in any doubt as to what sex a trans woman is. So a trans woman, biological male with a gender recognition certificate, who would then be legally female, but attracted to women, would become a same-sex attracted female, in other words, a lesbian. And I'm really pleased that they understood this argument because it was one that the Scottish court had failed to understand and that we'd made very strongly. It was a very important part of the lesbian submission to the court, and they really took it on board and understood it. And they said that if you were to use that certificated sex understanding of what a lesbian was, in other words, that it would include men who were attracted to women, then it would mean that the concept of sexual orientation to members of a particular sex would become meaningless. And that was their term, it would become meaningless. And they were also concerned that this would have particular practical implications, for example, for lesbian clubs and associations, which again was an important part of our submission, you know, whether or not we had the right to meet on our own without having to let in biological men. The Scottish government, faced with this dilemma, because they kind of knew that they sort of couldn't say no, lesbians can't meet on their own, really. They came up with 3 solutions, and I put solutions in inverted commas because they're quite laughable, really. And the judgment was absolutely scathing about all of the Scottish government's so-called solutions. So one was that lesbians could meet just on our own without having men there, if we only had small associations, because associations of less than 25 people aren't subject to the provisions of the Act. So in other words, if 24 of us formed an organisation, we could get together, and if another 24 people formed an organisation, they could get together. But if we joined forces and became 48 people, then we would have to admit men. And the judgment says that this suggestion is not only impractical, but also unprincipled, which I think is quite a strong sort of slap on the wrist for the Scottish government. And then in court, the barrister for the Scottish government said, well, it wouldn't matter if we let in men with a gender recognition certificate to our associations, because, you know, lesbians aren't attracted to every other lesbian that they ever meet. And so, you know, I, for example, wouldn't have to be attracted to this particular man who'd come into my, she didn't call him a man, this particular male with a GRC who'd come into my lesbian association. And so that wasn't going to be a problem. She didn't seem to understand the notion at all, or the Scottish government didn't seem to understand at all the notion of the importance of lesbian only or female only space. And again, the judges said this wasn't a solution, because whether or not we were attracted to a particular individual didn't in any way diminish the protections that we're entitled to as lesbians. And the third solution that the Scottish government's barrister came up with was to suggest that because believing in the immutability of sex is now a protected belief, as you'll know from the Maya Forstater case, that it would be possible for us to restrict membership of our lesbian associations to people, to lesbians who hold that protected belief. So as long as you were a kind of GC lesbian, you could be in a lesbian club of any size you wanted. But if you weren't a GC lesbian, then you couldn't be. And the judgment says that this demonstrates the incoherence of the Scottish government position. So basically, when they're looking at the situation for lesbians, you've got the government saying that they're unprincipled, impractical, and incoherent, which I think is pretty strong. And as an aside, I'm not sure, but I might have been the only person in the courtroom last week or week before when the judgment came out. I was in the courtroom along with a lot of other women, obviously, including some of the other lesbian interveners and our barristers. But I think I might have been almost the only person, or one of the few people in the courtroom who went in strongly believing that we were going to win, because I was so convinced of the centrality of the lesbian argument that I don't think everybody understood. I don't think everybody understands, even now the judgment's out, that it would have been, in my opinion, I'm not a lawyer, but I have said this before, that it would have been impossible, in my opinion, for the judges to find that certificated sex was the right interpretation to use in the Equality Act. Because if they'd done that, they would have had to square that with the notion that men could become lesbians by the acquisition of a single piece of paper, which anyway, we're not allowed to see. And that was so absurd and so kind of beyond the pale that I never thought that the judges were going to be able to find that way. I mean, there are obviously a lot of other reasons in favour of the Women in Scotland position as well. But I always thought that, and in fact, quite a few people have said, you know, that they agree that the lesbian question kind of solidified it, if you like, pushed it over the line. I think there's a phrase that somebody used, because it would have been impossible. Lesbians and lesbian clubs and probably pregnant men as well. There's absolutely no way, in my opinion, that the judges could have found against those two groups. So in short, the judges said, and I'm just going to read what they actually said, that using certificated sex means that all these provisions that I've been talking about, and I quote now, which refer to sex, man or woman, are not capable of being read fairly and consistently without defeating their purpose and meaning. The protected characteristic of sex, which is at the heart of this case, is not capable of being interpreted as certificated sex. Rather, sex has its biological meaning throughout this legislation. So that really was in a nutshell how they summed up their thinking and their reasoning, because you could not come up with a coherent, consistent, fair, meaningful argument if you went any other which way. After that, they also looked at a few other provisions. So single-sex services are allowed as an exception from the, as I think I mentioned, from the sex discrimination provisions of the Act. You can discriminate against men and tell them that they can't come in to our spaces. Again, we have the problem of how do you identify who's in which group if you use certificated sex? And also that it would be impossible to establish the conditions necessary for separate sex services, because if you say, in order to be able to have women-only services, you have to be able to justify the need for them to be women-only. But if you had to let in some men and exclude some women, then that didn't make any sense. You could never demonstrate that you'd met the conditions, because you wouldn't be, it would just be incoherent again. And so the judges said the legislature must have intended to allow the exclusion of those with the protected characteristic of gender reassignment, regardless of the position of a gender recognition certificate, in order to maintain the provision of single or separate services for men and women as distinct groups. So again, coming back to these same principles over and over again, you have to be able to identify who is and who isn't in a distinct group, because otherwise you can't coherently justify anything at all. You couldn't coherently justify the need for single-sex provision if members of that sex include members of the other biological sex. And the example they gave was a cervical cancer screening service, which obviously only applies to biological women, and so therefore is a women-only service, except that if you start saying that people have certificated sex instead of biological sex, then it's no longer a single-sex service, because some people who would legally be counted as men would still need the service. So they would either be excluded from it, or it would no longer be single-sex. So either which way, you're in a mess. So moving on a bit, the judgment also looked at situations where men can be excluded. I think this probably works the other way around as well, but I'm just going to talk about excluding men, where men can be excluded because women might have a reasonable objection to the presence of a person of the opposite sex. Some of the examples of those places are changing rooms, hospital wards, or rape crisis services. So, you know, those of you who've been following the Sandy Peggy case, for example, and the Darlington nurses, who know that in both cases, nurses have been expected to change in a room with male doctors who claim to be women, that this section applies directly in those cases, which is probably why Fife NHS has gone away saying, oh, we're going to study the judgment very closely, because it really makes a nonsense of their argument. And what they said is it's impossible to make a reasonable objection in practice if you use certificated sex, because the whole thing just becomes a mess again. When would it be reasonable to object to the presence of a man who self-IDs, but not object to the presence of that same man if he then goes away and acquires a gender recognition certificate? You know, what is it that would make your objection somehow go from being reasonable to not reasonable? That doesn't make any sense. How would the woman objecting to the man's presence know whether or not he had a gender recognition certificate? Because we've got all the same problems as before. And now there's a very important point that I think it was the end of a very long paragraph, and I think quite a lot of people are only starting to catch up with now, that the judgment also said that you can make a reasonable objection to the presence of biological women living in the male gender where they have had probably surgery or hormonal or medical interventions anyway. That's not a condition, but that's probably the reason, which gives them a very strong masculinized appearance. So in other words, if a woman walks in, if a person comes into your changing room, you know, and they're bearded and, you know, male pattern baldness and all the rest of it, you can throw them out, and they can't say, oh, but I'm really a woman, I'm a woman on testosterone, because that would be impossible to prove. I mean, this isn't the reasoning they gave, but that's what they said, you could reasonably object to that person being there. And I think it's really, really important, because without it, and I don't know if this is why the judges put it in, or whether it was just because they were being very, very thorough in their explanation of the legislation, but it means that without this provision, any man could have walked in and claimed to be a trans man, in other words, a biological woman, and it would have been very difficult for us to insist he leaves. So this, I think, is really important. I have to acknowledge it might also, for some people in that situation, present them with some difficulties, but that's going to have to be resolved at some point. a whole range of other single sex things are covered where there might be reasonable objections, situations where there might be physical contact, for example, like a massage service, communal accommodation, higher education, breastfeeding charities, and also they covered fair participation in gender affected sports. But again, I don't really have time to go into that. One thing that was very important was that they also talked about the collection of data. And they said that using certificated sex would mean that you are collecting data again on heterogeneous groups rather than distinct groups, and that this is confusing this group of people that includes some women but not all of them, and some men, and that the data collection will be distorted, and that the distinct discrimination and disadvantage faced by biological women cannot be addressed if you collect data in this very guddly way. So the rights of people with the protected characteristic of gender reassignment is obviously been causing an enormous amount of upset, and there's been violent protests. And, you know, I've had friends from the States writing and saying, oh, I'm really worried what's happening, you know, with all this violence and stuff. And of course, there's been an enormous amount of confusion and misinformation. So it's important to say that the ruling does not take away any rights from anybody that they already had. I think the difficulty is that for many years, people have been being told by Stonewall, by the Scottish Trans Alliance, by, you know, a whole load of other trans charities, that they have the right of access to wrong spaces if they self-ID as trans, never mind if they've got a gender recognition certificate. So loads and loads of people genuinely believe themselves to have this right. And what's a real shock to them, so the Supreme Court has now come out and said, no, you don't have this right. Actually, you've never had it. However, you do have a lot of rights under the Act. And people who self-ID, or people with, well, everybody with a protected characteristic of gender reassignment may have lost the delusion that they are can behave as if they were the opposite sex. But the ruling clarified that sex and gender separately rather than joined together, which is what had been happening, that there'd been this, basically the movement had been trying to merge the characteristic of gender reassignment with the characteristic of sex. And this ruling clarifies absolutely clearly that they are to be protected separately, that both groups. Under the Equality Act, people with the protected characteristic of gender reassignment have 3 different types of protections. They're protected on the basis of their sex, they're protected on the basis of their sexual orientation, and they're also protected on the basis of their gender reassignment. In other words, if somebody who's got the protected characteristic of gender reassignment is discriminated against because they're an actual woman, even though they, you know, try and present as a man, then that's sex discrimination. If somebody doesn't give them a job because they think they're a lesbian, then that's discrimination on the basis of their sexual orientation. And if somebody doesn't give them a job simply because they don't like the fact that they present as the wrong sex, and there's no other reason, then that would be discrimination on the basis of gender reassignment. So they have all those protections. And the other thing that's interesting and has always been part of the Equality Act, but really doesn't happen very often, but might happen in the case of some of these individuals, is that they have the right not to be discriminated against on the basis of perception. So in other words, if I'm heterosexual and you think I'm a lesbian and you're wrong and you don't give me a job because you've perceived me to be a lesbian and you don't give me a job for that reason, or you don't let me into your club, or whatever, however you discriminate against me, then I have a claim against you on the basis of sexual orientation. The fact is that you have discriminated against me for being a lesbian, even though I'm not a lesbian. Well, I am, but, you know, in this scenario, even though I'm not a lesbian, you've discriminated against me. So this is the same here. If a trans identifying male went for, I'm going to keep using the job interview examples, but it applies in anything else. If he went for a job and a self-IDing person, and he was perceived to be a woman, which he's not, and he wasn't given the job because he's a woman, because he was perceived to be a woman, he would have a claim for sex discrimination. So there's a very, very wide range of protections available to everybody. Generally speaking, the outcome's very good for women, but there's still an awful lot to do, because self-ID is deeply entrenched in many parts of UK society. And although the rulings are a really good basis to argue against it, we're not going to get rid of self-ID anytime soon. There's been this massive spread of disinformation by trans organizations, which is going to be really hard to overcome. And they're now telling vulnerable young people, oh, the UK is no longer a safe place for you to live, and the rule is incompatible with the human rights legislation, and that men still have the right to use women's toilets, none of which is correct, but is causing a great deal of fear and alarm. But the biggest one for me is what I've taken to calling Schrodinger's sex. I should have put a copyright mark after that, by the way, because the ruling doesn't undo the certificated sex that somebody has acquired through a gender recognition certificate. So males with a gender recognition certificate are male for the purposes of the Equality Act, because that's what we've just been talking about. But that doesn't apply to other laws. And in particular, the one that's been causing a lot of concern recently is about the fact that it might not refer to all situations where people are being strip searched. So there's a particular concern that a man who claims to be a woman can demand to be searched by another woman, or a woman PC, and that woman might then find herself in a difficult situation. But also, and this is old news, that they're still effectively regarded as men within the terms of the gender recognition certificate, because the GRA, the Gender Recognition Act itself, excluded the terms of the change of sex provisions within when you've got a GRA from applying in certain cases where if you came to inherit property or peerages, your status as a mother or a father isn't affected, as we saw in the Freddie O'Connell case, and participation in gender-affected sports. So in other words, these people have both sexes all at the same time, which are as recognised by the government, which I think is absolutely ridiculous. I've used gender here because that's the language used in legislation. It should say sex, of course. And in my opinion, more than anything, what this shows is the absolute importance of us getting rid of the Gender Recognition Act and all forms of sex falsification, because this is exactly the sort of mess that you get into otherwise.
Any comment on the EHRC saying that services don't need to have single-sex facilities, but can have all mixed sex? And what about women who identify as men being banned from women's toilets? How would that work?
Well, I think I mentioned the women who identify as men being banned from women's toilets in the sense that if they, present as men and they're taken to look, everybody thinks that they're men, then they can be banned from single-sex services. I think there is a real problem. One of the things that I've been really worried about is that in many cases where it's possible, service providers are going to go, oh, this is all just too complicated, I can't be dealing with it, let's just make everything mixed. So they'll make all their toilets or changing rooms or whatever mixed within the terms of the law. Now, there are some places in UK legislation, so the workplace regulations and the laws around schools require the provision of single-sex toilets and changing rooms. So in workplaces, as a member of staff, let's say I was talking to a friend who runs a pub about this the other day. I was saying that, so the law says that you as a member of staff in the pub are entitled to a single-sex toilet, but me as a customer, I'm not entitled to a single-sex toilet, because automatically entitled, because the big issue within the Equality Act is that it's largely permissive when it comes to single-sex provision. It's not mandatory. And so I think there's a real danger, and there'll be a big push from the trans lobby about this, that as many facilities as possible will be turned into being mixed. Now, in some places, that's obviously not possible. I mean, you're not going to be able to do that in terms of sports, for example. But even hospital wards, there are such things as mixed hospital wards already. They've always existed. I wouldn't be surprised if we don't see them pushing to have mixed wards so that anybody can be anywhere they want. So I think it's a very good question. It's a very big problem, and I think I think there's going to be a lot more court cases. I think this is the beginning of the battle, very much nowhere near the end of it. I mean, although we're seen to have been, you know, obviously we're delighted, because without this we wouldn't even be at the starting point. But with this ruling, that there's still an enormous amount of work to be done to roll back the nonsense that's occurred over the last 15, 20 years.